Dear students, I welcome you to yet another lecture on corporate law. The topic for today's lecture is the duties of directors. The duties of directors are numerous. Any omission or commission of an act in contravention of the lawful duty of a director gives rise to liability which he has to suffer. A director is required to be reasonably careful in performing his duties. Otherwise, it creates liability not only for the director himself but also for the company and other defaulting officers. The duties of directors have been incorporated in Section 166 of the Companies Act 2013. Section 166 of the Companies Act reads, Number 1. Subject to the provisions of this Act, a director of a company shall act in accordance with the articles of the company. Number 2. A director of a company shall act in good faith in order to promote the objects of the company for the benefit of its members as a whole and in the best interests of the company, its employees, the shareholders, the community, and for the protection of environment. Number 3. A director of a company shall exercise his duties with due and reasonable care, skill and diligence, and shall exercise independent judgment. Number 4. A director of a company shall not involve in any situation in which he may have a direct or indirect interest that conflicts or possibly may conflict with the interest of the company. Number 5. A director of a company shall not achieve or attempt to achieve any undue gain or advantage either to himself or to his relatives, partners or associates, and if such director is found guilty of making any undue gain, he shall be liable to pay an amount equal to that gain to the company. A director of a company shall not assign his office, and any assignment so made shall be void. Number 7. If the director of a company contravenes any provisions of the section, such director shall be liable with fine which shall not be less than rupees 1 lakh but which may extend to 5 lakh rupees. The Companies Act of 1956 did not lay down specifically any duties of the director. The field was occupied by common law. It is important to remember that codification of duties in Section 166 of the Companies Act 2013 cannot be said to be an exhaustive enumeration of the duties of the directors. Common law principles laid down by the courts from time to time are still relevant in enumerating the duties of the director. Now, dear students, we shall discuss the duties of the directors under certain headings. The first duty is duty of good faith. This duty is the most basic of all duties. What is meant by bona fide and is in the best interest of the company is that a director must at all times ensure that his actions are consistent with the well-being of the company. In Cook versus Deeks, a contract offered to the company was rejected by the directors, who subsequently accepted it in their personal capacity and made some profit. It was held that the directors were liable to account for such profits. The court observed, I quote, "Men who assume complete control of a company's business must remember that they are not at a liberty to sacrifice the interests in which they are bound to protect and while ostensibly acting for the company, divert in their own favor business which should properly belong to the company they represent." Unquote. A director who acquires property only by reason of the fact that he was a director and in the course of the exercise of the power of a director, he shall be liable to the company if he makes any profit on the resale of such property. Regal Hastings Limited versus Gulliver is an authority for this principle. The company, that is Regal, operated a London cinema. The defendant was one of its directors who proposed to the members of the company that it purchase 2 other cinemas. This opportunity was declined. Accordingly, the directors resigned from their position and set up another company by the name of Amalgamated. Amalgamated purchased the cinemas with a view to selling them back to Regal and operated them successfully over the next few years. As a consequence, the value of the directors' shares in Amalgamated increased. The new directors of Regal then brought a claim on behalf of the company against Gulliver and the other former directors to require them to account to Regal for this profit, arguing that this was an opportunity they had obtained as a result of their position as directors of Regal. Gulliver replied that the profit had been made as a result of his own effort and acumen. There had been no impropriety on his part, and Regal should not benefit from an opportunity which they had declined to take up in the first place. While accepting these arguments, the House of Lords, by a bare majority of 3:2, found that as the opportunity to purchase the cinemas had arisen as a result of his directorship of Regal, Gulliver had a duty to account for the profit he had made, regardless of the fact that Regal had declined this opportunity. The case therefore demonstrates the strictness of the prohibition on conflicts of interest, irrespective of the intention of the directors. In Industrial Development Consultants Limited versus Cooley, Mr. Cooley was the managing director of the Clement Company. His duties included procuring business in the field of developing gas depots. The company had unsuccessful negotiation with the Eastern Gas Board for the development of 4 depots. However, the Gas Board were not prepared to let the contracts to the company. The Gas Board subsequently approached Mr. Cooley in his private capacity and indicated that they would be prepared to contract with him personally. Mr. Cooley therefore resigned from his office on the basis of a false excuse and entered into contracts with the Gas Board. The court held that he was accountable for the profit. Where a fiduciary obtains a benefit in breach of his fiduciary duty, he is liable to account even if the beneficiary could not itself have obtained the benefit or opportunity. The second duty is duty of care, skill and diligence. The directors of a company are expected to perform their functions with reasonable care and attention. They must discharge their duties with skill and diligence as expected from a reasonable person of his knowledge and experience. They are, however, not liable for bona fide errors of judgment as observed by Justice Romer in Re City Equitable Fire Insurance Company. In this case, in the course of winding up of an insurance company, the liquidator found a shortage of funds, this loss being largely attributable to the fraud of the managing director. While it was found that the other directors were not implicated in the fraud, the liquidator sought to make them liable for negligence in authorizing or making poor and unwise investments and loans and for the payment of dividends out of capital. He did not succeed, mainly because the company's articles exempted the directors from any liability for any non-willful loss or damage they might cause. Justice Romer's judgment, which was affirmed by the English Court of Appeal, summarized the duties of skill, diligence and care into 4 propositions. Number 1. A director must exercise that degree of skill and diligence as would amount to the reasonable care that an ordinary man might be expected to take in the circumstances on his own behalf. Number 2. A director need show no greater degree of skill than may be reasonably expected from a person of his knowledge and experience. Thus, the director's care and diligence must be judged on subjective criteria. Regard must be had to the director's personal qualifications and experience, not to some objective minimum standard. He need not bring any special qualifications to the office. Only if he has knowledge and experience appropriate to his tasks will he be expected to demonstrate a commensurate degree of skill. Number 3. A director is not bound to give continuous attention to the affairs of the company. The duties, Justice Romer added, are of intermittent nature to be performed in the boardroom and on subcommittees, but there is no duty to attend all board meetings or shoulder responsibility for decisions made in his or her absence. Number 4. A director can rely on other officers or experts. Modern, large businesses rely on effective delegation by the boards of directors of subordinate and administrative tasks to subordinates or experts. Boards delegate to accountants, auditors, lawyers, executive committees, managers and other company employees and trust in and rely on their advice. The question that arises is, can the directors rely on the official and experts to perform these functions? Justice Romer in Re City Equitable Fire Insurance Company Limited qualified his affirmative answer. He said, and I quote, "In respect of all duties that, having regard to the exigencies of business and the articles of association, may properly be left to some other official, a director is, in the absence of grounds for suspicion, justified in trusting that official to perform such duties honestly." Unquote. The standards laid down in Re City Equitable Fire Insurance Company Limited are considered lax in the present times. The focus now is on the level of responsibility taken on by the directors rather than the directors' actual level of expertise or experience. It is likely that the courts will continue the line of applying a higher standard of care and attention to the business by all directors. The standard required is that to be reasonably expected of someone occupying the office in question. In Dorchester Finance Company Limited versus Stebbing, it was held that the duty of care extends uniformly to all the directors, whether they are executive or non-executive directors. Thus, the two non-executive directors of a company were held liable for the loss caused to the company due to their negligence in signing blank checks which enabled the executive directors to enter the amount as they pleased in those checks. Exclusion of liability. Section 201 of the Companies Act 1956 did not allow liability for negligence to be excluded. It rendered void any provision in the company's articles in any agreement which excluded liability for negligence. However, there is no analogous provision in the Companies Act 2013, but now the duties of the directors have been incorporated in Section 166 of the Act. No modification of the duties is permissible. Therefore, liability for negligence cannot be excluded. However, Section 463 extends special protection against a liability that may have been incurred in good faith. Section 463 says, and I quote, "Where in a proceeding for negligence, default, misfeasance, breach of duty or breach of trust, it appears to the court that the director sued has acted honestly and reasonably, and having regard to all the circumstances of the case, he ought fairly to be excused, the court may relieve him either wholly or partly from his liability on such terms as it may think fit." The third duty of a director is to attend board meetings. Section 167, Clause 1, Subclause B provides that the office of the director will be vacated if he absents himself from all meetings of the board for a consecutive period of 12 months with or without obtaining leave from the board. Moreover, a director's habitual absence from the board meetings may, taken in the light of other circumstances, become evidence of negligence on his part. The fourth duty is duty not to delegate. A director as an agent is governed by the maxim delegatus non potest delegere. This means that a delegate cannot further delegate. There are, however, two exceptions to this rule. Firstly, a director can delegate such functions which the Act or articles of the company permit him to delegate. Secondly, delegation is permissible where, due to exigencies of business, certain duties are left to be discharged by some other officials of the company. It is important to remember that delegating responsibility in a proper manner and to a proper extent by the board is permissible, but total abrogation of responsibility by the directors is prohibited. Pertinently, Section 166, Clause 6 provides that a director of a company shall not assign his office, and any assignment so made shall be void. In Dovey versus Corey, a banking company suffered heavy losses due to huge advances given to certain untrustworthy persons without taking proper security. Also, the payment of dividends was made out of capital. All this was attributable to the machinations of the chairman and the manager who manipulated the accounts and showed a profit. The defendant director was ensured of the correctness of the accounts presented to him, and he authorized the payment of dividends, which were actually paid out of profit. Holding the director not liable, the court observed that a director is entitled to rely upon the judgment, information and advice of a fellow director whose integrity, skill and competence he has no reason to suspect. Lord Halsbury observed, and I quote, "The business of life could not go on if people could not trust those who are put in a position of trust for the express purpose of attending to the details of management." He could have been held liable only if he had some reasonable grounds to suspect the honesty of other officials. This principle was followed by the Madras High Court in Doss versus C.P. Connell, where a person who was discharged insolvent was appointed as an advisory director of a banking company. He misappropriated part of the security money received from the employees of the company, which was put at his disposal. The liquidator did not succeed in his efforts to charge his co-directors with the liability. The court observed that the respondents had no reason whatsoever to suspect the integrity of the chairman. Insolvency does not necessarily mean that a person is dishonest. However, directors cannot always shrug off their responsibility and escape liability by saying that they knew nothing and believed that everything was all right. For example, in Palai Central Bank Limited versus Joseph Augusti, a banking company paid taxes and dividends for 22 years out of profits which they had not really earned. The directors pleaded that they had made the payments on the basis of accounts prepared and certified by competent staff and auditors. The court, however, rejected their contention and held them liable for deliberate falsification of accounts. Referring to the magnitude of the loss involved, which could not be easily explained, the court observed, and I quote, "Not one of them cared to disclose who were the persons in actual charge of these matters, what exactly were the duties imposed on them, and what scrutiny there was over their work in order to assure that it was done properly. At the best, plea of the respondents can only amount to a plea of complete ignorance born of a complete inadvertence to their duties as directors, reckless indifferences, or otherwise put a willful shutting of their eyes." The deliberate falsification of the books year after year could not have been the handiwork of the staff of the company. It could only have been at the specific instructions of those at the helm of affairs. In a company, the directors are at the helm of affairs, and although the rudder might be in the hands of the managing director, it is their duty to keep an eye on him and see that he steers a proper course. The fifth duty of a director is the duty to disclose interest. The director stands in a fiduciary relationship to the company. It is his duty to avoid conflict between his personal interest and his duty to the company. Consequently, for the proper discharge of his functions, it is imperative that he is free from any conflicting interest. If he has any interest, he is duty bound to disclose it. In Aberdeen Railway versus Blake Brothers, Blake had a conflict of interest as a director of a company and managing partner of a firm which supplied office furniture to the company. Despite the fact that the price the company paid was fair, the company was entitled to set aside the contract. In Ramaswamy Iyer versus Madras Times Printing and Publishing Company, under the company's articles, two directors constituted a quorum for a meeting of the board. Two were present and they appointed one of themselves as managing director and co-director of the paper run by the company. The appointments were held to be invalid as when the vote of the interested director was excluded, there was no quorum to make the appointment in each case. Section 184 of the Companies Act lays down the procedure to be followed in the event of the director being interested in a transaction with the company. Section 184 reads, Disclosure of interest by the director. Every director should disclose his concern or interest in any company or companies or bodies, corporate, firms or other association of individuals, which shall include the shareholding in such manner as may be prescribed. Clause 2 states that every director of a company who is in any way, whether directly or indirectly concerned or interested in a contract or arrangement or proposed contract or arrangement entered into or to be entered into, A, with a body corporate in which such director or such directors in association with any other director holds more than 2% of the shareholding of that body corporate or is a promoter, manager, chief executive officer of that body corporate, or with a firm or other entity in which such director is a partner, owner or member, as the case may be, shall disclose the nature of his concern or interest at the meeting of the board in which the contract or arrangement is discussed and shall not participate in such meeting. A contract or arrangement entered into by the company without disclosure or with participation by a director who is concerned or interested in any way, directly or indirectly, in the contract or arrangement shall be voidable at the option of the company. Dear students, this is all with regard to the duties of a director. Hope you have been able to understand the various duties of a director. Stay blessed.